Hey everyone, welcome back to the channel. Today we're diving into one of the most important Supreme Court decisions in recent years, Loper-Bright versus Raimondo. This case has completely changed how federal agencies interpret and enforce laws, and it could reshape the balance of power in Washington. Let's break it down in 10 key points so you know exactly what's at stake. First up, Loper-Bright versus Raimondo officially overruled the Chevron doctrine. For decades, the Chevron rule meant courts had to give federal agencies the benefit of the doubt when laws were unclear. Basically, agencies got a thumb on the scale. But the Supreme Court said that practice violates the Administrative Procedure Act. From now on, judges, not agencies, will have the final say on how laws are interpreted. So when the law is vague, agencies no longer get to decide what it means. Courts will review everything de novo, starting from scratch. Under the old Chevron system, courts took a two-step approach. Step 1. Check if the law was ambiguous. If it was, then Step 2. Defer to the agency's reasonable interpretation. That's all gone now. This decision wipes out a key part of how the executive branch exercised power over environmental policy, healthcare, finance, and more. If you're finding this breakdown helpful, don't forget to hit that subscribe button and turn on notifications. I've got more deep dives like this coming your way. Now, how does Loper-Bright connect to other major cases? One big one is West Virginia versus EPA. That case used Chevron but warned agencies not to stretch vague laws into sweeping powers on issues of major political or social significance. After Loper-Bright, that warning becomes even stronger. Agencies will now have to prove Congress clearly authorized what they're doing. But don't think the major questions doctrine is gone. It's actually more relevant than ever. It ensures agencies don't go beyond their limits when making big policy moves. The discussion also touched on something called the public rights doctrine. That's where certain benefits, like Social Security, can be handled by administrative agencies instead of the courts. But when it comes to private rights, things like property, contracts, or torts, those must go to court, where citizens have the right to a jury trial under the 7th Amendment. A great example is Judiciary versus SEC. The court ruled that securities fraud claims can't just be decided by agency officials, they must be tried before a jury, in court. That's a huge shift in how the SEC operates. Finally, the video ends with a senator asking, can anyone ever ignore a federal court order? The answer? Only under extraordinary circumstances, if ever. The point is clear. Court orders must be respected. This shows how Loper-Bright isn't just about technical legal rules. It's about reinforcing the separation of powers and judicial authority in our system. In short, Loper-Bright versus Raimondo marks a massive power shift from agencies back to the courts. It's one of those rulings that will quietly shape government for decades to come. If you want more summaries like this, make sure to subscribe, drop a like, and share this video so more people can understand what's changing behind the scenes. See you in the next one.
Tell me about the Loper-Bright case.
Sure. So Loper-Bright is the case that overruled the Chevron doctrine. And the Chevron doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper-Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron doctrine?
Sure. So the court would originally make a step 1 determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper-Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper-Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper-Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper-Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkissi, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my better judgment, Senator Schiff, I promised Senator Schiff, because I skipped him in order, I promised him one more question. All right, Senator. This gavel will never come to me again, though, if you ask more than one question. So we'll hold you to it.
Well, I've got the gavel.
This is
Well, there we go.
this is just in honor of Mike Lee's birthday.
Yeah, be sure I understand, Professor. District court rules in a case. You got plaintiff or defendant and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So, of course, as a judicial nominee, I would be trying to issue proper orders.
I don't want to split hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you
My-
think of any circumstances where you would tell the plaintiff, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine
Like
that
what?
could come before me as a
Like
judge.
what?
So this is a subject of
I'd be
tremendous
careful
scholarship.
there. I'd be real careful.
All
there,
right,
Professor.
Senator. All right. I promised you one. That was 4, I think.
Okay.
See what you started, Adam.